Welcome to the first of 3 nights of Lenten Soup Supper. I was unsure if we needed all these tables, but y'all showed up, so thank you. It is great. We still need soup for the next 2 weeks, so sign up if you have a recipe that you want to try to outdo from tonight. So this 3-night series, we are talking about something that is hard to talk about, and that is the fact that we will, in fact, someday die. And any of you who have lost someone who did not want to reckon with that can know how challenging it can be to make decisions for someone not fully knowing what they might have wanted, hoped for in terms of their possessions or their funeral, or even how they would have wanted to be cared for in their final days. So that's our series for tonight and the next 3 nights. So I'm going to introduce parishioner. I was trying to find the fanciest title. Counsel, David Tekell, to come and talk about wills. The goal for tonight is really for an overview about what it means to have a living will or a will, and then for you to be able to ask David pretty practical questions about what it looks like to prepare in this way. So welcome, David.
How's that? Can y'all hear me okay? Robert? You got me? There we go. I'm mic'd up. For those of you that don't know me, I'm David Tekell. I am a longtime parishioner here at St. Albans, and I play a lawyer on TV. I don't do estate planning, but as the major focus of my practice, I do about 10% of that. But I went to law school and I learned how to do that, and they gave me a license. Jerry Campbell said, "What are you going to talk about?" And I said, "I don't know." He said, "What do you know about wills?" I didn't teach you anything about wills. And I said, "Well, I probably don't know as much as you, but I know more than them. So I'm going to try to share some of the things." As I got up here, Aaron reminded me that in the prayer book, part of the admonition to the priest is on page 445. The minister of the congregation is directed to instruct the people from time to time about the duty of Christian parents to make prudent provision for the well-being of their families, and for all persons to make wills. This is in the prayer book. All persons to make wills while they are in health, arranging for the disposal of their temporal goods, not neglecting if they are able to leave bequests for religious and charitable purposes. So part of the prayer book's admonition is that we need to prepare for the orderly disposition of our possessions and to, of course, think about the church in those provisions. I'm going to talk a little bit about estate planning, about what happens when you don't plan, things that you might want to think about in doing some planning, and some things that maybe are already in place, and then talk a little bit about how to make a will, and hopefully won't take too long in going through that, and then I'll open it up for questions and answers, questions anyway. I'm not sure I'll have any answers, but so if you would be thinking about some questions. There is no test. There are there's no handouts. I've got one slide that I may try to show you later, but otherwise this is hopefully something that you can follow along with me. So the thing I thought would be important for us to talk about is what happens to your stuff when you die. What happens to your soul when you die? That's Aaron's business. Ask him those questions. But what I can talk to you about is what the law, what the legal community, what a judge will do with your stuff when you die. It is not, it doesn't come up when you die unless you actually have some stuff. And it really doesn't come up unless there is some uncertainty amongst the people that survive you about what to do with your stuff. So part of estate planning, in fact, the great part of estate planning is for the survivors, for the people that are left behind. And so sometimes people will say, well, why do I need a will? You don't need a will. By the time that will comes into operation, you don't need it. You're gone. The people that need the will are your survivors, and you're doing this for them. And conversely, you might think about that. If you have someone that you love, worry about a spouse, a child, a parent, and you think at some point you come to the realization that they are mortal and that they will die, and that you and the rest of your family need a plan for what to do with their stuff, they're the ones that you should encourage to get this estate planning and get a will. Because it's for your benefit that this estate planning will be done. So, I, for instance, with my mom's a great procrastinator. I'm sure she's confident, even at the age of 83, that she's not going to die anytime soon. But I convinced her, and in fact said, I will pay the lawyer for you to go and get a will so that I don't have to worry about this. I don't care what you put in it. I just want this done. And so this is for the living. You should do this as a matter of caring for your loved ones, and for those of us that love people who maybe don't see that as a need as much, we need to, I think, encourage them to think about this and make these provisions. All right, so a will is a legal document that says this is what happens to my stuff when I die. That is what the state or the judicial system is most concerned about. Rachel talked about you might put in your will what kind of burial you want, what kind of songs you want sung at your funeral. In reality, the court doesn't care about that stuff. That's going to be taken care of between you, or frankly your heirs, and the church or the priest. I could put in my will, for instance, that I want a Hindu wedding performed by Aaron Zimmerman without any clothes on. And put that in my will. Fortunately for Aaron, no judge is going to make him do that, despite the fact that I put it in my will. You can put all kinds of things in your will, what you would like to happen, but the reality is what we're really looking for is the disposition of your property. So let me talk about property a sec. We've got to, in order to kind of understand why we might be concerned about property, I think we need to understand a little bit about what kind of property we have. In Texas and in the United States, we break property down into two major categories: real property, dirt, real estate, buildings, residences. That is what we call real property. And then personal property is pretty much everything else: cars, boats, musical instruments, money in the bank, securities, stocks, bonds, annuities. Those are all considered personal property. And the state often treats those types of properties differently. Well, you can say, well, I don't have a lot of that stuff, and that may very well be the case. The more of that you have, the more I think there will be a concern that you have a disposition of that when you die. Now, we already have, in all likelihood, because we live in the 21st century, we already have a number of ways that we have made decisions about estate planning already with some of our personal property. For instance, if you go and open a bank account these days, more often than not, they will have had you sign an account agreement that tells the bank about the disposition of the money in that account upon your death. And so you might have an account called a POD, or payable on death account, and you will name someone in that document as the beneficiary. So when you die, regardless of what your will says, the money in that account will go according to the account agreement. You may have a joint account with a survivorship. You may designate that this is my account that I own with my spouse or with my child. And so we can both write checks out of here, but upon one of our death, it goes to the other one. And that, again, that disposition of that bank account occurs regardless of whether you have a will and regardless of what you put in your will. It is something that occurs as a result of that contractual agreement that you've made with the bank. So oftentimes, that is an excellent way to be thinking about disposition of your property or estate planning when you open a bank account. If you have, for instance, a retirement account at work, a 401k or an IRA, most often in those account agreements that we set up, we will name a beneficiary in that account. So for instance, if I leave my retirement account to my spouse, when I die, that account goes to my spouse, regardless of anything I've put in my will. If I leave it to my children, it will go to my children, regardless of anything I've put in my will. And so those are excellent ways to think about the disposition of monetary accounts or accounts with securities in them. You'll have that opportunity, and those wishes will be honored. You may have annuities, you may have life insurance. Life insurance is kind of the same way. Most often, life insurance, when you take out a life insurance policy, it will ask you to name a beneficiary, someone who the insurance company pays, maybe a group of people that the insurance company pays upon your death. And upon your death, upon proof by those beneficiaries, the insurance company will pay those people that you have designated as beneficiaries. Again, this is all regardless of what you might put in your will or would otherwise happen even if you didn't have a will. So those are some very common ways that we already have available to us to make dispositions of some of our monetary assets outside of having a will. So what about real estate? So real estate is real property. In real estate, we don't often have the same types of opportunities. So if we own a house, if we own multiple properties, we may own those jointly with someone else. We may own those individually in our name. And the legal owner of those properties is who has been deeded that property, who has been named in the deed to that property. And as far as the state or the law of Texas is concerned, that property will remain in the name of that person until there's some further disposition by a will or a deed from that person's name. So even if I have a property that I own jointly with my spouse and I die, my spouse will still be on that deed, but there will be a need for the disposition of my share in that property to be made. I went to school in California. California has and some of you may have come here from California. California has a thing called a joint survivorship, and most of the deeds to married couples there are made with jointly with rights of survivorship. When I came to Texas, I was like, okay, well, let's do that. That would mean that when I die, immediately all of my interest in that property would go to my other owner or my spouse. Texas doesn't look at that and doesn't use that very often. And so we look for then a disposition of that property separately. And oftentimes that disposition is done in a will. So even if you own property jointly with someone, you still have to worry about where your share of that property goes. And we don't have as much ease in making a document, and certainly after the fact, after we've acquired property, like we would with an account at a bank. We don't have as much ease to say, when I die, I want this to go to this person. There is, and you may have heard something called a ladybird deed or a transfer on death deed that has come into Texas law in about the last 10 years. And it is a mechanism that is available now so that someone that is anticipating, that is thinking about their estate planning and wants to do a transfer of a piece of real estate to a particular person on their death, Texas law now allows you to be able to do that. So you can sign a transfer on death deed that says, when I die, I want this property to go to my 2 children in equal shares. And then that transfer on death deed is in the records, and it becomes operative upon that person's death. You don't have to go to probate. You don't have to have a will. That particular deed then takes care of that disposition. If you acquire the property, you might, there are some other ways you might say, well, I'm just going to hold this for a while. I'll call this a life estate, and then it'll go to these heirs upon my death. Those are not particularly common ways to do dispositions of real estate, but they are available. So I'm kind of backing into why we need a will or what a will does by showing you that there are some other things that you can do for the disposition of your property, but oftentimes you do need a will. Let me talk about some other things before I get into what a will does and how to make a will that you might also want to think about in the context of estate planning. So when we do an estate planning package for clients, we will ask them to think about 3 other documents, one being a financial power of attorney, one being a medical power of attorney, and one being a medical directive to physicians. And so just let me highlight those briefly. These 3 documents that I've described are documents that are operative while you are still alive, but perhaps incapacitated. So a power of attorney is a written document that appoints someone else to act as your attorney, someone that acts as your agent or representative, not as a legal attorney to go practice law, but as someone that acts as your agent, and they can do things with their signature with your property just the same as if you were signing or doing those acts. So I might give a financial power of attorney to my wife if I'm incapacitated, if I just happen to be in jail in Mexico on drug charges and I need her to go loot the bank account in order to get me out of Mexico. She can use my power of attorney to go to the bank and take the money out of my bank account and wire it to Mexico and hopefully get me out. If I'm otherwise incapacitated, if I'm out of the country and or for some other reason just not able to do something financially, another person with that power of attorney can act in my place and get that done. So that's something that we ask people to at least think about putting in as part of their estate planning. That is separate and apart from something called a medical power of attorney. A medical power of attorney is instead of being focused on financial transactions or real estate transactions, is focused specifically on medical decisions. So it might be something, I did one, for instance, for my secretary a couple of weeks ago because she went into the hospital for an operation. And she wanted to provide a mechanism for her husband to make decisions about her health care while she was under anesthesia, or in case something went wrong with her operation. This medical power of attorney would be a document that the hospital or the doctors could rely on, and then give her designated agent, in this case her husband, the authority to make that decision. Yes, she needs that extra amount or that extra liter of blood. Yes, she needs that admission into that facility in order to care for her. And I, as her medical power of attorney, have the authority to do that. And you, as the hospital, have the ability to rely on my decision to make that for her. And then the third document that I described is a medical directive. We have a form in Texas that asks you a couple of fairly personal questions about what you would want if you were on life support and you were not able to make decisions for yourself. And so you can think about these questions, such as, if I am declared brain dead and it does not look like I can be resuscitated, that I will ever become conscious again, I want everyone to continue to keep me alive and use all heroic measures and freeze my body for 200 years in case that cure comes through. Or B, let me go. Allow me to die naturally and give me palliative care, give me something for pain relief, but don't otherwise try to prolong my life. In other words, it's okay to pull the plug on me. And so you can make that decision while you're, sober, while you're completely healthy and thinking through these things. And if the unfortunate time ever comes for your loved ones to have to make that decision for you, they will at least have something in place that shows what you have thought about, and they will know and feel comfortable. I know this is his wishes. I know this is her wishes in this instance, because they went through this and made that decision in that medical directive. So those are some other types of documents that you can think about. All right, so now I'm going to get into then what I've saved for last, which is making a will. So a will is your directive on what to do with your stuff. What do you want to do with your stuff? Do you want it to go to your spouse? Do you want it to go to your children? Do you want it to go to your secret girlfriend? Do you want it to go to the church? Do you want it to go to science? Do you want to set up a trust for a cat that you want to take care of? This is your time to tell us what to do with your stuff. It becomes important, of course, when there is uncertainty amongst the living on what to do with your stuff. Frankly, if everybody agrees and they want to go and take your stuff and divide it up or give it to charity, if everyone that's interested in that agrees and no one disagrees, they don't have to go by the will. They can just do what they want. Now, I couldn't, for instance, say I want 10% of my property to go to the church, and my heirs go, well, let's just no, we don't. We want to just take the money for ourselves. They couldn't do that. But if the church agreed, hey, y'all just take the money, we disavow any interest in that will, that would be something that would be okay. It is in the face of uncertainty or disagreement that this will becomes important. So we talk about probate. Probate is the process of asking the state, here the state of Texas, to enforce your wishes to the best ability of the law. And so someone that's interested in that will take that will to the courthouse, put it in front of the county judge, and ask the county judge to accept that as the wishes of this person, and then preside over the disposition of those properties so that they are disposed of in accordance with that will. And the judge, if the will is proper and acceptable, will give, usually an administrator, oftentimes we call them an executor, will give them the legal power and authority to perform the acts necessary in order to make that disposition. So that's what we want if there is any uncertainty or potential for disagreement. We want to have a disinterested person, a judge, the state with the authority of the state of Texas to give that disposition the full faith and credit that you wanted in that will. So that is what we call the probate process. Obviously, people can disagree. The will didn't say that. The will did say that. I don't think that person knew what they were doing, so I'm going to contest the will. That's another class. What we want, though, is we want this judge to give our loved one the comfort and the authority to make this disposition. And so Texas law has several ways that it will take a will and enforce that will. Most oftentimes, the way we do a will is what we call a self-proving will. A self-proving will under Texas law requires that the person sign the will. It'd be in writing, of course. The will's in writing. It's signed by the testator, the person that's making this disposition. It is witnessed by 2 disinterested witnesses who are at least 14 years of age. And all of their signatures on this document are notarized by a notary public, who is likewise a disinterested person, someone that's not going to inherit through that will. And so that's what lawyers do. We will prepare this document. We will round up witnesses around the office or on the same floor and have a notary, and we'll have a big will signing ceremony where the person signs this document in front of these witnesses. And the benefit of having it self-proving means that a person can take it down to the judge, and just upon the signatures alone on the document, the judge and the court will accept it as a will and enforce the wishes in that will, including giving the named administrator authority to act on behalf of the estate, give them what we call letters testamentary. And so that's the easiest, slickest way for a will to be accepted in probate. But there are other ways under Texas law that we can do wills. We don't have to have a big ceremony with lawyers. I've got a case now where the woman sitting in the hospital wrote her wishes out in handwriting on the back of an envelope and signed it. And the family is like, is that good? Well, so Texas law provides for what we call a holographic will. A will that is entirely in the handwriting of the testator and signed by the testator will be accepted or can be accepted as a holographic will. And the court will accept that. And of course, the court will want to hear evidence, and someone will have to come in and perhaps swear, I saw this happen, or I found this, and this is in fact this person's handwriting. But that type of will, not witnessed, not notarized, can be accepted as a valid will under Texas law. So, and then a third way I wanted to talk about is you can have a witnessed will that doesn't have either one of those things but still is accepted. So if I do a will, it's not completely in my handwriting, I have someone type out, I leave my entire estate to my wife, Angela, and I sign it, and I get Stuart and Tracy Kelly to sign off on it, I've got a will, and it will be accepted. It'll take some extra steps. Angela and Tracy and did I say Kelly? Stuart, well, yeah, all 3 of them will have to go down to the courthouse and swear that this is the will, that they witnessed it. But upon their oath, the court will accept that will as my last will and testament, and will give force and effect to it. Without those types of attributes to a writing, the court will not give it the force and effect of a will. And in that instance, if there's either a defective will or no will at all, the person's estate will go according to the laws of intestate succession. I don't memorize these very well, so I brought a little chart that helps me show them what they are. And let's see if I can get this fired up real quick to show you kind of what the laws of intestate succession are. All right, let me into the Wi-Fi and then do sharing. And then I want to go to Parish Hall. And you should maybe see my family up there. And then I'm going to go over here. And let's see, does that show a chart? Okay, so this is a chart that we often use to talk about intestate succession. So what happens if you don't have a will? This first box shows, the heading is married person with children. And it has two different areas. We have community property and we have separate property. So I have to tell you a little bit about that. In Texas, we have this thing called community property. Hopefully you know what that means. It means the property that you acquire while you are married, during your marriage. The things that you and your spouse acquire jointly together, usually income, sometimes real estate, are presumed to be your community property, and you hold them together. And so your community property, when you die with children, goes all to your surviving spouse. Separate property is things that you might have gotten by gift or inheritance, things that you brought into the marriage before you were married. So if your family leaves their business to you when your father dies and leaves you this business that he wants you to carry on, that's going to be your separate property in all likelihood, because that came as a gift or through inheritance through your family, and it's going to pass differently because it's considered separate property. And here we see that my separate property, if I don't have a will, 100% of it is divided equally among my children. Not my spouse, like community property, but it all goes to my children. But my spouse then has what's called a survivorship widow's estate in it. She has a life estate, so that means she can take money out of that business during her lifetime, but she can't pass it and otherwise own it. So that is married with children that are the children of that marriage. If these are children, and this often happens, I get this. This is where problems occur. You get remarried, and the children of your first spouse aren't real excited about your second spouse, and then when you die, there's a big fight between your children and your second spouse. If you don't have a will, this is what happens to it. Under your community property goes half to the surviving spouse and half to your children. That's a happy situation. Believe me, everyone's happy about that. Not. There is always a fight about that. And this is the fight that we're trying to avoid. If you are the spouse, you want to avoid this fight. If you are the children and your parent has remarried, this is a fight you want to avoid. This is a situation you probably don't want to be in. You don't want to be having your stepchildren move into your house because they now own half of it. Right. And half of it means they get to occupy every inch of it, just equally with you. That is not a fun situation to be in. Separate property kind of continues to go to the children. but then that new wife who's now a widow gets the same rights to participate in a life estate. So if you don't have a will, and you've got complicated family situations, these are the issues that you're going to create for your loved ones. And these are the issues that we want to avoid. None of your property goes to St. Albans. None of your property goes to the state. None of your property goes to charity unless you want it to. You have to make a designation for that. So, to the extent you think you're a charitable person and you want, maybe after you have used and had the benefit of these properties during your lifetime, it might benefit a charitable purpose, this is the place to do it. You do it in your will. I'll say one more thing about that, and then I will open it up to questions. As part of my, and it's not a very good service, but part of my service back to St. Albans is that if you come to me and want to do a will, and you'll leave 10% or more of your estate to St. Albans, I'll give you that will for free. I will not charge you for that will. I haven't had a lot of takers on that, don't get me wrong, and I haven't advertised that. At one point when I started, I didn't want to supplant other lawyers or think that for them to think I was better than them because I was doing this, or try to get a big estate planning. But I have found that other lawyers are like, no, you go ahead, you got that. That's all you. But if you would like to do that for St. Albans, then I will help you do that will, and I will do that at no charge. All right. Thank you for your attention, and I'll be happy to answer any questions.
I'm going to do one pause because you segued so well. So first, thank you.
Yeah.
And speaking of estate planning, I'm going to invite the Rev up to talk a little bit about that before we go to questions.
I'm just going to talk really briefly and say that I've been at St. Albans for 10 years. I've probably done something around 50 funerals here or so. And in that time, only one of those funerals had somebody with a will that designated anything to St. Albans Episcopal Church. Now, we are, relatively speaking, a fairly young church. But this is an easy way for you to be able to do something significant that will have a really huge impact, kind of ripples that go out over time. So if you could put 10% of your estate, most people, their estate is in their house or some financial assets, and if you can designate some part of that to the church, for example, to the endowment fund, that is the kind of thing that has a big impact over time. St. Albans Endowment Fund, at the peak of the market before the recent downturn, we had reached the lofty, intoxicating heights of $810,000. That endowment fund is now worth about $660,000. It was established in 1976, so 30 years after our founding, and since then it has grown relatively slowly. The last time there was a significant just gift, outright, sort of not, memorial gifts come in throughout the year, often in relatively smaller amounts. The last time we had a significant gift to that fund was in 2011, 2012, around then. So really, all the growth of that fund, from it was about $500,000 when I got here, and then it got up to $800,000, all that was market fluctuations, not sort of big gifts. But I just put that out there, something if you'd like to impact St. Albans 50 years from now, 100 years from now, including St. Albans in your will is a great way to do that. And so if you have any questions about that at any time, I'd be happy to meet with you. We have a handy brochure about it, and there's lots of creative ways to think through that if you'd like to do that. And David would be the expert on the technical stuff, but if you want to know how to create something significant for the church, I'd be happy to talk to you about that. Any questions before I hand it back to Senor Tekell? Okay, thank you. And this was not a big ploy, by the way, to get you to put St. Albans in your will. I promise you. But it is something the prayer book does say that I should tell you, that it is very difficult on your survivors if you don't have a will. And since we're talking about wills, your family, when they are grieving, you don't want them to have, I see people go blank when I say, can you pick a scripture for the funeral? There are so much stress And they don't know what to do. They got to pick a hymn. And then you had the financial pressure of it as well. So this is why it's important for me as your pastor to say, make a will for the people that you love. As David said, not for yourself, but for the people you love that will be around after you die. And since you can, if you want to tithe what God has given you to impact this church for decades to come, there's a really easy way to do it, and a really nice guy that'll help you do it. So that's all I want to say. Yes, Kimberly. Absolutely. I mean, if you were to say, for example, I want to be careful here and say that the vestry ultimately has responsibility on all the assets of the church. And if you were to say, I designate my 10% of my estate to go to the Carillon Maintenance Fund at St. Albans, and sometime between after you write this will and it takes effect, lightning strikes the tower, and all the bells melt into one giant mass and are never replaced, the vestry would have responsibility of how to distribute those funds in a way that hopefully honors the intent of the person who wrote the will. So yes, but I would say on that. And if you wanted to have a conversation, for example, St. Albans does not have a mission endowment. Some churches have an endowment which provides money for just generally for the church, for the operation of the church. That's kind of what ours does now. It helps a little bit every year to the operating budget of the church. Some churches have a mission endowment, which the proceeds from that every year are decided by a committee, usually a mission and outreach committee, how those will be used to help organizations, nonprofits, charities in the community. Some churches have a long-term maintenance fund, kind of an endowment for that, which if the boiler goes, you don't have to take all the money out of the operating and pay for that. We don't really have those other two things. We just have one general endowment. But if somebody said, I'd like to put into my will something where they would go to this kind of endowment for this specific purpose, I think the vestry would be happy to talk about creating that with a small seed fund so that vehicle is there to accept those assets when the person dies.
All right, so questions recognizing general questions, maybe not specific to your very life situation. Those can be saved for later. And I'm going to bring the mic so that everyone can hear everyone.
My question is regarding the difference between if you mentioned that if you had a bank account, that if it had the cosigner, it would automatically go to that person. But then how does that differentiate from if I wrote, I would like to give this percentage of my estate to the church? If I want to give 10%, then does that also apply to the direct bank account, or how is that settled?
That's a good question. So I'll answer that broadly, and then we'll dive down into that in that particular instance. So if you put a will together, you're probably going to say something like, I give all of my estate, or the rest, residue, and remainder of my estate. There's going to be a gift that's fairly broad. And what the court would look at that and say, what they're talking about here are their probate assets, the things that haven't been disposed of in some other way. And since that bank account was disposed of in some other way, then the court would not enforce that general statement against that particular account. Now, you might say in your will, but I want 10% of my account at Valley View Bank, account number 972, blah, 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 and I want 10% of that to go to St. Albans. Well, chances are that would be enforced, even if you had that payable on death disposition at that account. That would certainly leave enough confusion to where there might be something that there would be a dispute, and it would be the best to say that in both places, so that you do not have your church fighting with your grandmother about who gets the money in that account, or your children. So, yeah, do it both ways, and don't leave that confusion.
So many questions. But I'm going to start with one. Say that you used to be really on top of these things, and you made a will or a trust in another state before you moved here. Mm-hmm. Is that still in effect?
Did it happen to involve a prior marriage with another woman?
No, sir.
Did you live in a state that allowed multiple women, you to be married to multiple women?
Maybe.
I'm gonna put a stop to those questions pretty quickly. No, you do not have to have a will in Texas in order for it to be enforced in Texas. Usually your estate is done in your place of residence. So if you've done a will in Utah or California and you come to Texas and establish residency in Texas, the court is going to take that will and enforce it here in Texas, and it would be subject to probate and enforcement here in Texas. We would still apply Texas law with respect to whether or not it's got these self-proving attributes or whether we need witnesses or not. But these descriptions, these attributes that I've described are fairly ubiquitous around the country, so it's likely that your will created in another state has complied with those niceties and those requirements already. Good.
So if you have a will set up and it's to wherever it's going to individuals or organizations, do you need to give a copy of that will to those people mentioned?
That's an excellent question. So not just, imagine you leave my office with this will and you give your estate to a multitude of beneficiaries. How are they going to know that? I can't tell them that. I am your lawyer and I'm required to keep your confidences. Now, I will encourage you to tell the beneficiaries that you have designated that you have left this provision in the will. And so I will encourage you, for instance, to take a copy of this will to your children. I will encourage you to take the original to the person that you have designated as your executor, or to at least let that person know where this original will is so that they can find it if they need it. And certainly if you have left a disposition to a charitable institution such as St. Albans, you should let them know, because otherwise they will not know to even look for that gift, much less a way to enforce it against somebody who may not be excited about enforcing that gift. You can make a copy of that. You can direct me to make a copy of that will and give it to the church. You can make a copy yourself and give it to the church. You know, this is a relatively small institution. You know, if chances are, if someone gave left a will 20 years ago that they've put somewhere in the office, I don't know, Padre, would you know where to find that?
I would know where to look.
Yep, you would know where to look. Yeah. So, you might need to remind
Nancy knows
them.
where to find it.
You might need to remind them, or at least remind others that disposition has been made.
My question actually it goes right along with this, and I've had the medical power of attorney, all of that stuff done because I have health issues. I also have a will, et cetera, and I sent them to, well, originally it was my father. He's since passed away. Then sent a copy to my brother, and he's moved several times, and it just, has gotten lost all the time. Nobody knows where this is. I have an original copy, and I just, if my house burns down or, how does somebody come in and find it? I guess what I'm asking, and I know the absolute wrong place to put it is a safe deposit box, because, yeah, I do know that. Mm-hmm. But so then where's the best place for safekeeping? That's my question.
Yep. So the lawyers used to keep wills in their safes. Good lawyers don't do that anymore. because the lawyers recognize that that's just a liability and it's just a problem. So we will almost always send that person away with the original and tell them to give, to at least tell the people that are going to need it that where it is. So you might have a fireproof safe in your house and you got a big label on the front of it that says will in here. You just got to let somebody know where it is. And if you give it to the person that's going to need it, that's probably the best thing. Hopefully they can keep it safe. The court is going to want the original. You can prove a copy of a will, but there are some extra steps and some testimony that the court is going to have to take in order to enforce a photocopy of a will. So we are most concerned about that original. And then let me address the shared humor about the safe deposit box. So the bank has a safe deposit box, and they give you a key. And unless you have that key, you can't get in that safe deposit box. And you can show up at the bank and go, my dad banked here, and I'm pretty sure he's got his will in a safe deposit box here. And the bank's going to go, you're not your dad. You got a key? We're not letting you in unless you do. And so you can't get the bank to let you in to get the will. You can't get the bank to drill it without the key. You now have to go to the court and ask the court for a court order to open the safe, and this is the whole thing you were trying to avoid to begin with. So putting it in the safe deposit box without giving the person that's going to need it the key to it is not a good idea. So don't do that. Yeah.
I am the executor for the estate of friends who have children, but not the listed guardian in the will. And their reasoning behind that was they wanted the person who was dealing with the logistics of the property and all of that to not be the person also worrying about the care of their children.
Right.
But that was the first I had ever heard of that situation. And can you comment on the wisdom of either making the guardian the executor or not?
Sure. So there is, if you are a person that has young children, you need to think about what happens to your children when you die. The court will not take your children away from your spouse because you left your children to your sister. So you can't just say, in case I die, I want my kids to go live with my sister. Your sister will be, she'll be relieved to know she's not going to get your kids. They're going to go to their father. They're going to go to him. So these are situations that occur because both parents are no longer around, and perhaps there aren't any grandchildren. Now, the probate court is not going to be particularly concerned with what you have put in there. This is something that's going to be maybe helpful in case there is a dispute or there is another court proceeding in district court with respect to what happens to your children. Who's going to be their legal guardian? Okay, so now both parents are gone. We've got minor children. In all likelihood, we're going to have a parent, a grandparent, maybe a sibling step up and apply to be that guardian. And your disposition in your will have some influence over that, but will not be determinative. The judge will not say, oh, well, you're the great parent, or you're the grandparent, and you're here, but she wanted it to go to her ex-boyfriend over in California, so I got to enforce that. Not going to happen. The family member is going to have extreme priority over that. But if there is some concern amongst the family as to who ought to apply for that, having that disposition in your will be helpful. Does that make sense?
Yeah, but you answered. She wanted, her friend made her the executor and someone else the guardian.
Someone else is the guardian. And you want...
Well, I'm curious for our own kids and if that were to happen to us, what is wiser to
Is it wise? Right. Yeah. So the executor is there to dispose of the will, and there probably is a provision in the will for someone being the trustee. Now, the court will often enforce that as the wishes. So, for instance, I say, if both you and Daniel die, you may have your mother as the trustee, but they go, yeah, right, for your children until they reach the age of 25. So she now is burdened or benefited with the ability to take their money, your money, and hold it for them in trust until they're 25 years old. So that person that is designated as the trustee, so we will often provide in a will something, and this may be what you're thinking about. If the person or set of persons that takes this inheritance is younger than the age of blank, 25, 40, 35, is 18, but you don't want to give a 16-year-old, having had two 16-year-old boys, you don't want to give them $100,000 because someone dies. They're not, they're going to buy fast cars and maybe fast women. You want an adult to step in their stead and hold that money until they are more adult and more mature and will be able to use that money, hopefully, in making mature decisions. At the same time, when they are underage, they can't open a bank account. They can't buy a car. They can't use this money or write a check or things like that. So we need to have an adult that has those powers step in and be that representative for them. And so that's often the use of that person as a trustee. Good?
All right, we are actually out of time, but the good news is you know where to find this guy, and there's also other lawyers in the room that can also help. But we do have a last word / question from Al that I want to make sure we get to.
Our first will made provisions for who got our kids. If we died, who are going to get our little kids? Those kids are in their mid-40s right now, and they'll probably fight to give them away. Our last will was done by Tekell and Tekell. So the thing I want to beg you, or as Aaron would say, by the bowels of Christ, don't try to do this on your own by paying $15 on your computer. Get a good attorney.
Yeah. No, do, Al. Let people do it on their computer. It makes me a lot of money if they do.
I've been sued
Those are
in my
expensive
previous
fights.
job. I was sued about 15, 16 times, state court, and about 8 in federal court. I won all of them because I had very good lawyers. And I learned to love lawyers. Everybody hates a lawyer until you need them. Okay, so and you go to them, or arguable another lawyer, but if you go to them, they'll take you by the hand and go, now, this is what you need to do. They did everything, I know that if I'm getting ready to die and there's no chance Carol can unplug me and all that, but get an attorney that can do this.
Thank you.
Thanks, Al. Thank you, David, for speaking to us tonight. Just a few housekeeping things. The first one is next week we have Andrew and Kara talking to us about prayers for the sick and dying. So we'll be drawing from our prayer book and from Kara's hospice care experience. And so that'll be a very different mood than tonight. But then really our third night, we're going to tie it all together by talking about both the theological and the practical when it comes to funeral planning with Aaron. So really talking about what that looks like. And I think we'll have like homework, the whole shebang. That is it. Let me pray for us. The Lord be with you. Nice. Let us pray. Lord, thank you that there are practical tips I feel like that was the Lord entering. Lord, thank you that there are practical tips to look after those when we can no longer look after them. Help us to face what is really scary and unsure with confidence that they will not be alone in this. Lord, be with us tonight and always. Amen.